Hello and welcome everyone. Today we are again here with a legal current affairs session. Today we'll be discussing the three important topics again. The first one being the most important for all the judiciary aspirants and the students who are going to get into the law school and are thinking of themselves becoming a judge, right? So recently we know that there was a 3 years of imposition, 3 years of compulsory practice before you can write the judicial paper, but that has been reduced, and it is really a good news to all the students who were already preparing for it, right? Because earlier when a student graduated, they were used to write the paper as soon as they grad, right? But later on, court said they need 3 years of practice because the freshers who were coming to the court as judges were not that much qualified. They had a very less knowledge about legal practice, right? So what that court has done is they have came up to the conclusion that it should be reduced to 3 years to 1 year. Right? This is a major amendment that has been done recently, and this is for the junior level. Okay, junior division civil judge examinations with respect to all the state judiciaries, right? So I already told you the background though. The background is in 2002 the Supreme Court had removed the mandatory practice, and at that time they also came up with a new training system. Okay, so they had a training of each and every judge, but later on in 2025 there was the requirement of with respect to 3 years that was increased, which led a lot of students to come down to not writing the paper, go to the court and practice first and then do the write the paper, right? Now finally we have come up to 1 year, but then there are other things which are mandatory as well. So candidate must have at least 1 year of legal practice. For 2027, the relaxation has been given as soon as the student grad, they can write the paper, right? But there is an important second part. Candidates selected under the revised system will undergo 2 years of training. So they will go for 2 years of training before they can independently preside over courts and decide cases. The basic reasoning is that judge should have at least some real world exposure of litigation, because I told you the freshers were not that much qualified with respect to the litigation part and the courtroom functioning. Two objectives: instead of requiring 3 years of practice, they need 1 year of practice, judicial selection, 2 years of training, and independent judicial work. Why is this important? Because earlier it was 3 years practice, then judiciary exam. Now it's 1 year judiciary exam, 2 years of training. The exam pointers, you already know, 3 years came down to 1 year. The case, All India Judges Association versus Union of India, restored 3 year practice, training 2 years, entry level judicial system it is. Next, cabinet approves permanent Ladakh bench for J&K High Court. So now they have the permanent bench, which is there in Union Territory of Ladakh on 20th of August on 2026. This is significant because it creates a permanent judicial presence within the Ladakh. One more important thing, LR and English nuggets is available for 999 rupees for all the non-CL students, and for the CL students it is available for 499 rupees. Okay, so go to law entrance, click on enroll now button, go for self-paced program, choose LR nuggets, LR and English nuggets, and purchase it right there, right? So it is available just for 1,000 rupees, and for CL students, already existing students, it is for 499. Not a bad deal to go for. So go and purchase it right now. Okay. Moving on, we have background of Union Territory and Jammu and Kashmir. The existing High Court here became the High Court of Jammu and Kashmir. Ladakh currently functions from Jammu and Srinagar. Okay, the permanent Ladakh bench will add Ladakh as third judicial location. Why does Ladakh need a permanent bench? Is Ladakh presents unique geographical challenges, extremely difficult terrain, long distance, then harsh climate conditions and limited connectivity in several areas. Sparse population for litigants from Ladakh traveling to J&K, Jammu or Srinagar for court proceedings can be expensive and time consuming. A permanent bench therefore aims to bring justice closer to citizen. What is a permanent bench? Does it mean? It means High Court bench is a place where judges of the High Court exercise the court's jurisdiction. Permanent bench means that judicial functioning is institutionally established at that location rather than depending primarily or temporarily or circuit arrangement, something which is permanent in nature, right? Access to justice, of course. Administrative convenience, yes. Constitutional governance, strengthening and judicial infrastructure, basic key significance, important exam, High Court of Jammu and Kashmir and Ladakh. Not a separate High Court of Ladakh. Okay, it is not a separate High Court. The High Court will have judicial location associated with Srinagar, Jammu and Ladakh. 214, go and check out the article 214 for sure, okay? Jammu and Kashmir Reorganization Act of 2019, High Court jurisdiction, Union Territories, judicial accessibility, constitutional institutions. MHA transfer CAA application processing to district collectors. So MHA is Ministry of Home Affairs has decentralized the processing of pending citizenship application under the Citizenship Amendment Act 2019 CAA. Under this amendment, the district collectors have been empowered to process CAA citizenship application specified states and union territories. The amendment was notified on 19th of August. So what has changed majorly? Previously, applications were handled through empowered committees. Previously, applications were handled Union G and departments such as Census, IB, postal authorities. The new arrangement processing responsibility will get into district collector's hand. The change applies to Gujarat, Punjab, J&K, Assam, except tribal areas, Rajasthan, WB, Ladakh, Tripura, except tribal areas. Okay, what can district collectors do? They can undertake functioning, synchronize documents, receive application, verification information, conduct inquiries, minister oath, determine eligibility, grant citizenship. Quick CAA background, if we see, it is the 1955's amendment done to 2019 Act. It created a special pathway to citizen members of 6 specified religious communities from 3 neighboring countries, that is Afghanistan, Bangladesh, Pakistan, Hindu, Sikh, Buddhist, Jain, Parsis, Christian. The legislation are politically, legally contentious and its implementations have been closely watched. Why decentralize the process? This move is essential for sure, and it's faster processing, easier documents, reduce administrative bottlenecks, better access for applicants, local level inquiries. So that is it. All the 3 are really important, and again, LR and English nuggets. If you are struggling with your logical reasoning part with respect to critical reasoning and analytical reasoning, go for the LR and English nuggets. And even if you're suffering for English, then this is the best course for you. It's not expensive. Go and buy it right now. That is it from my end. Thank you so much. Bye-bye. Take care.